Welcome to Module 2.6, the key forms of intellectual property, or IP, and how to protect IP. This is part of the Interreg Italia-Malta INO programme, although all the material has been developed here at the Centre for Entrepreneurship and Business Incubation, the University of Malta. This particular component, 2.6, is part of Track 2, which relates to products and services. And we're looking here at an overview of products and services, and we're looking now at intellectual property, what it is that you own that you're going to sell. The session is designed to increase your general understanding of the different types of IP and the associated legal framework. We're not expecting to make you experts in the law, but to give you a good overview. Firstly, do you recognize this symbol? Well, actually, it's the symbol of the Bass Beer Company. And believe it or not, this was the world's first registered trademark. And here's the original first trademark from 1876. And so any design can be used as a trademark to help customers recognize the beer, in this particular case, by a simple symbol. And symbols were often used, particularly in the early days, rather than words, simply because at that time, not everybody was able to read and write. So what is intellectual property? Well, the property is a bundle of rights to own, use, and prevent others from using something. It could be a plot of land, a car, or a house. Intellectual property is a bundle of rights that protects applications of ideas and information that have commercial value. IP rights give creators certain exclusive rights over the knowledge and information they create to prevent others using it without permission. Knowledge, ideas, and creations are partial public goods. Intellectual property, IP, confers a set of time-limited legal rights over the expression and use of certain ideas. And the legal force of IP prevents others from using it. So really this is trying to help the originator, the person who's created things, that when they've branded it with, for example, a trademark, and stops people from using it and pretending that they're selling the same thing as a competitor. And this is right and proper. Why do we need it? Well, to incentivize knowledge creation and hence wealth creation. If we didn't do that, if we couldn't protect things, there'd be no point in developing new products. It means, in the bigger picture, we can accumulate knowledge in a culture, but it also helps to protect a distinct identity. What are the benefits of IP protection then? Well, the IP rights create legal barriers to accessing or using knowledge or information by granting exclusive rights to inventors and creators. It prevents free riding on investment. Ideas are expensive to produce, but cheap to copy, remember. It enables rights owners to exploit their knowledge or creativity in the market. Overall, it's an incentive to innovate. But there has to be a need for balance. So the issue of IP rights is a trade-off. There are economic incentives to innovate. There can be a monopoly on prices, cost to consumers, and prevention of access, but it's usually time-limited, with eventual lapse into the public domain. And that's for the benefit of the public overall. Patents are one form of intellectual property. They're a set of exclusive rights granted by the state to a person, the inventor, for a fixed period of time, 20 years in the European Union, including Malta, in exchange for the regulated public disclosure of certain details of an invention. This prevents others making, using, selling, offering to sell, or importing the claimed invention. The right does not give the patentee the right to make, use, or sell the invention. What are the criteria of patentability? There are 4 key ones. Number 1, novelty. Number 2, there has to be an inventive step. Number 3, there has to be industrial applicability. And number 4, not to be on the excluded things, a list of things that are not allowed. Novelty then is defined as, to be patentable, subject matter has to be new. The details of it must never have been made public before submission to patent authorities in any form, including in writing or by way of oral description. An inventive step. This is something which is when compared to what is already known, such that the inventive step would not be something obvious to one skilled in the art, as it's referred to. There has to be an industrial application, which is defined as being capable of being made or used in some kind of industry. And finally, number 4 is not excluded. And things on the excluded list include not a discovery, mathematical method, aesthetic creation, business method, or something that's unethical. Copyright is different from patents. Copyright is very different in the sense that copyrighted work cannot be reproduced, distributed, communicated to the public, lent, rent out, or publicly performed without the owner's consent. And it covers a wide range of creative or artistic forms. That can include plays, books, movies, audio recordings and drawings. It can even include software, checklists, protocols, toolkits and guidelines. But please note there's no official register and copyright arises automatically. It automatically comes into effect when the work is created. So copyright then covers the way in which the work is expressed rather than the idea behind it. There are some exceptions to copyright, and that covers a number of areas. Firstly, transaction rights, e.g. in a book review. It's perfectly okay to quote a small part of a book if you're writing a review of that book for a magazine or a newspaper. It's okay to translate anything into Braille without fear of breaching copyright, and that's quite right, of course. Copying for non-commercial private research under library privilege is possible, and then copying and communication for education is also possible. Copyright lasts for a long time. 50 years for computer programs, and 70 years from the date of the death of the author in literary works. Trademarks are a little bit different, and they are really a badge of origin for goods or services, and they can be applied for 10 years. It could be a word, a logo, a colour, a shape, or a sound. And here's an example for McDonald's. Also a tagline, I'm loving it. And notice that the golden arches, as they're referred to as the R in a circle, that means it's a registered trademark. You have to pay for that. But the I'm loving it has TM. That means that the trademark has not yet been registered, but McDonald's have actually put TM by the side of the phrase to indicate that they believe it is theirs. It does not cost anything to do that. Trademarks, once registered, give rights to prevent others from using similar marks on similar products, and they promote and provide brand loyalty. A loss of protection occurs when the trademark ceases to be used or becomes generic. For example, when a brand name comes to stand for a general class of items. For example, the name Hoover was the name of the manufacturer, but it's now used in general terms to mean a vacuum cleaner. Registered designs relate to the appearance of a product, including its shape, configuration, and ornamentation. Protection lasts for 5 years and it can be renewable to 25 years. Design must be new and have individual character. For example, the Coca-Cola bottle. The overall impression it produces on an informed user must differ from the overall impression produced on such a user by any design which has already been made available to the public. Know-how. This is perhaps the most important intellectual property and yet the form most often neglected. Closely held information in the form of unpatented inventions, formulae, designs, drawings, procedures and methods. It's a key component in any innovative work, and it's an alternative to, or in conjunction with, the formal IP route, so confidential information or the trade secret. For example, the Coca-Cola recipe is simply a trade secret, not divulged to other parties. Finally, intellectual property is everywhere. Looking at this jar of Nescafé Gold Blend, there's a huge amount of intellectual property. From the way in which the plastic is made to form the cap, the way the bottle is formed into that shape, all of those could be patented. The names, the logos, the colours, all of those could be trademarked. The text that appears on the front, but more typically on the back of the jar, could be copyrighted. And there's substantial know-how. For example, where do the beans grow? How do you roast the beans? How long do you roast the beans for? How do you freeze dry the beans to make the Nescafé Gold Blend? So IP is everywhere. The important thing for any enterprise is to recognize it and protect it in the most effective way. So at the end of the lecture, here's where I'd ask you for any questions, but for now it's enough to simply say thank you for watching.